States are sovereign and therefore have jurisdiction to make laws that lord over their territories and subjects. As states on the international plane are all equally sovereign, the creation of law that is typically seen as the duty of a legislating body is absent. Jordan quoted Professor Kirillov, the first Soviet judge of the International Court of Justice, that just as the primary source of domestic law is a statute, the primary source of international law is an international treaty. International law sources its guiding principles or rules per se on how a state should behave from the behavioral patterns of those states in its past. The source of international law will be understood to mean recognized manifestation of international law. Thus, how and why does a state accede to international lawmaking treaties? In general, codification of principles of law by way of treaty formalizes international law for clarity. It is easier to crystallize principles of international law in a document rather than looking for a pattern of state practice and to look for evidence that points towards a state's belief or opinio juris that it was to abide to when applying customary international law principles. Meyer says that codification of customary international laws by way of treaties solves some of the practical problems with customary law by clearly delineating the steps that mark the creation of a legal obligation. So, what is a treaty? A treaty is an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. Therefore, is a treaty simply a contract between states? It is analogous to a contract in that it creates binding obligations for parties arising therefrom and can set out the repercussions if a state breaches its terms, such as a withdrawal or termination of the treaty, similar to the principles in the law of contract. This is in line with the pacta sunt servanda rule in customary international law that all agreements made need to be kept and be performed in good faith. If states do not amicably resolve a dispute raised within 12 months by the means specified in Article 33 of the United Nations Charter, and unless the states in dispute submit it to arbitration, a breach of a state's obligations under the treaty will be furthered at the International Court of Justice. This gives an avenue for treaty parties when a dispute arises to get a neutral party to adjudicate the dispute, and this is in line with the goals of the United Nations post-World War II that disputes should be settled peacefully. A treaty may only be terminated subject to the provisions of the treaty and by design are difficult to get out of once ratified and enforced. To cater for the extenuating circumstances, a force majeure defense and a necessity defense has been enshrined in the International Law Commission's 2001 articles on state responsibility, particularly Articles 23 and 25 that have provided for derogation from treaty obligations, but only in extraordinary situations. However, arguably the largest selling point for treaties to encourage participation of states in international law making is reservations. All states have differing cultures and political views, and thus international laws that they would like to accede to might need slight adjustment to take into account those differing views. Reservations allow the Vienna Convention to balance the need to respect the conditional consent of reserving states and to honor the unqualified consent of the treaty by the non-reserving states, and bridges the gap between the differing heterogeneous states and the need for consensus per Dr. Hardani and Jacobs. The ingredient that must be present for a treaty to come into being is the intention to create legal relations between themselves, and Shaw propounds that this sieve is logical since there are many agreements between states that are mere statements of objectives and are thus not intended to bind each other. As a democratic state's sovereignty is embodied in its government, the consent of a state to adhere to international laws and be bound to any consequences if there is a breach of its obligations is more formal in nature. A head of government, head of state, or ministers of foreign affairs that are representing the state prima facie is deemed to have full powers to conclude a treaty. Any other person seemingly representing the state, however, must produce express full powers, or circumstantially it is clear that the state intended that person to represent them for the purposes of concluding that treaty. Consent of the state to be bound by a treaty can be given via inter alia signature or in exchange of instruments, and a monist state such as the Netherlands can conclude and be bound by the treaties quicker. However, by far the majority of treaties are concluded by giving consent by a state through ratification. This allows the treaty to be laid before Parliament in a dualist state such as the United Kingdom, and thereafter the state can be said to have ratified the treaty after it has been given consent by the true sovereign Parliament. However, for a convention or treaty to have legal force in domestic courts, it still has to be incorporated into municipal law. For instance, the Human Rights Act 1998 has imported the legal provisions of the European Convention on Human Rights. Thus, the requirement that treaties be deposited with the Secretary General of the United Nations, and the important step of a state giving proper consent to be bound by a treaty gives legitimacy to the international laws that are created by way of treaty, and enhances trust between states from the lessons learned from the world wars in the earlier 20th century. Ratification and the further step of incorporation means consent of a state to be bound by the treaty provisions is more comprehensive, and thus gives more clarity to the international community that the state's government has a vested interest and intends to keep to its international commitments. For instance, the Convention on International Trade in Endangered Species of Wild Fauna and Flora 1973, an international treaty to prevent animal or plant species from becoming endangered or extinct because of international trade, and has 183 states currently party to it. It is a lawmaking treaty in that in 1975, when it entered into force, it laid down new rules that state parties must comply to in order to coordinate enforcement action against flora and fauna illegal smugglers, which obviously is transborder in nature. Shaw suggests that lawmaking treaties, such as CITES, which involve a large number of states to elaborate and express their views through necessity of what the law governing that at the time new and critical area of law that will help to prevent international wildlife trafficking, and thus create previously non-existent rules that will bind all. There are also agreements that declare the existing law or codify existing customary international law rules. For instance, the right of innocent passage of ships as applied in the Corfu Channel case is now codified in Article 17 of the United Nations Convention of the Law of the Sea. The drafting of treaties bilaterally or multilaterally allows new states to partake in the codification process, and therefore gives more incentive to the states to be a party to such treaties. Also, it gives more buy-in for those states to adhere to the treaty provisions. Kapczynski opines that codification is usually helpful in binding new states which maintain that they are not bound by the old customary laws elaborated by Western states, because they actively took part in elaborating the contents of those codifying treaties and in deciding to become parties to them. Jordan thus points out that the former Soviet Union, now modern-day Russia, had a preference for treaties as the primary source of international law as compared to customary international law, because it is a breakaway from the one-sided Western views that it claims it did not consent to as a sovereign state. Even though the Vienna Convention on the Law of Treaties only governs treaties between states, it does not prejudice any treaties concluded between international organizations. This is perhaps so because there is a need to distinguish the primary subjects of international law, which are the states due to their sovereignty, but also allow room for treaties to be ratified between international organizations and states, such as the UNHCR, and to recognize international organizations and the non-states in general as having the capacity as subjects of international law due to their growing role and influence in international relations in the 21st century. Lilienthal and Ahmad in their article said China recognizes treaties and long-followed customs as primary sources of international law, provided they meet the just and equitable requirements of its 5 principles of peaceful coexistence. This very one-sided view of picking and choosing what applies to its actions and what doesn't shows that the state is placing its sovereignty above all else at the expense of others. For instance, the 1979 Moon Treaty, which came into force in 1984, thus far has been ratified only by a handful of states, all of which have no capability to explore outer space by themselves. Therefore, the spacefaring superpowers such as China, the United States, and the Russian Federation, who have all consciously chosen to avoid being bound by this treaty obligation. Although the treaty is bypassed by the major powers, the attempt to set ground rules in what Jia calls the norm-creating treaty allows the identification of problematic provisions of a treaty, which is suggested to be Article 11, that disallows discovery of mining of natural resources on the surface and subsurface of the moon, as this can be inferred to cause states to avoid wanting to be a party to the treaty in the first place. The provision can be amended at some point through this feedback loop when the need arises in order to encourage participation. However, the 1979 Moon Treaty is perhaps largely ignored because of the overlapping existence of the 1967 Treaty on Principles Governing the Activities of States in the Exploration and Use of Outer Space, which has been more widely accepted by 111 parties. It sets out broad principles on peaceful use of space and that no state shall claim sovereignty to outer space, including celestial bodies such as the moon. Shaw cited the example of the North Sea continental shelf cases, where West Germany, due to non-ratification of the Geneva Convention of 1958 on the continental shelf, was not obligated to heed to its terms. Thus, if a state does not actively participate as much as others in ratifying treaties, does it mean that there are no international laws that it is bound to observe? In the Nicaragua case, a custom and a treaty can exist in parallel. Jia propounds that they do not, therefore, supplant or subsume each other. A cause of action arising from a dispute may be founded in either. A rule of customary international law not only reflects a general practice of reiterated actions of states, but also the belief on the part of states that compliance is required. When a practice is followed by states as a legal obligation, or in the words of Article 38 of the Statute of International Court of Justice, accepted as law, it may be considered to be an international custom. The Vienna Convention on the Law of Treaties between states and international organizations, or between international organizations, of 1986 in its preamble states that where a treaty does not govern a certain issue, customary international law shall apply. It rather demonstrates that customary international law continues to exist alongside treaty law. The areas governed by the two sources of law thus does not overlap exactly, and the rules do not have the same content. States are usually willing and keen to ratify human rights treaties such as the 1984 Convention Against Torture and other cruel, inhuman, or other degrading treatment of punishment to gain international recognition and prestige, but are aware any effort to enforce a party to adhere to the provisions would need a deliberate and open act of the other states to pressure the recalcitrant state. Hathaway suggests that the problem lies in that the strongest means of treaty enforcement, military intervention, and economic sanctions are used relatively infrequently to enforce human rights norms because there is little incentive for individual states to start the ball rolling and take on the burden of engaging such enforcement activity. Also, treaties need ratification by signatories, which might take months or years, if at all, to successfully incorporate the international treaty obligations into municipal law. For instance, Malaysia has been teetering on the ratification of numerous international human rights treaties, namely the International Convention on the Protection of the Rights of All Migrants, Workers, and their members of their families, even though there are socioeconomic migrants and refugees numbering in the millions, and in the Convention Against Torture and other cruel, inhuman, or degrading treatment or punishment, because it does not want to abolish the death penalty. To sum up, treaties are an important aspect of lawmaking in the international community, as it allows inclusive participation of states in legislating international law and at the same time upholds the sovereignty of states. Peace treaties allow the ending of conflict And investment treaties give stability and protection to actors in the international arena of commerce and business. International organizations growing in influence and function in international humanitarian crises in the 21st century can be given recognition and authority through treaty. New areas of international laws can be made by enacting lawmaking treaties such as space law, and customary international law can be codified to enshrine and crystallize all customs for clarity and ease of access. Treaties can help to create new state practice when states arrange their actions in compliance to treaty provisions, and when accompanied with the requisite opinion juris can create new customary international laws in the future. Treaties are by design flexible with the feature of reservations to allow differing states with differing socio-economic and political backgrounds to cater to their domestic legal requirements when they become parties to a treaty. However, the doctrine of consent that underpins this formal source of law means that some treaties can be disputed by belligerent states to not apply to their actions if they are not party to those treaties. Also, the age-old question of effective enforcement is something that will be perpetually hold the application of international law back in part.